Okay, so my name is Will Dybel. I am doing the Henry Benjamin FB case. So Ben was a student in the Des Moines School District. He attended Roosevelt. He was enrolled in Central Academy. It's for gifted students. So he's a very talented student, very intelligent. And according to all accounts, he was good in his AP courses. He kept a 3.0 GPA. He got in those AP courses anywhere from a C to an A, and just had some small problems with truancy and tardiness. But on record, nothing else very big. He was diagnosed with ODD, so oppositional defiant disorder, dysrhythmia, which is basically an abnormality in physiological, rhythm. So maybe like brain or heart. I'm assuming it was the heart. It doesn't go into a lot of detail there because that's not as relevant. And ADHD in 1998, which would have been when he was around fifth grade. His doctor, psychiatrist, believed his ODD was improving, but his ADHD hadn't gotten any better, and he had been on Ritalin for that long time. And at some point during his time, he switched from one doctor to another because the one had moved. And so both doctors, though, had described him as impulsive and destructive with relationships. He was not a diagnosed IEP student, nor was he part of a 504 plan. But again, he had been on medication for ADHD since fifth grade. What happened is his senior year, he actually was caught smoking by an associate at Central Academy. When this associate addressed it, Ben refused to come to the office, and so that associate then contacted the vice principal, who I'm just going to put as VP on here instead of writing it out. So the vice principal determined where Ben would be next and met him there. He pulled him out into the hallway, so it wasn't a public location, and then confronted Ben. Now, when the vice principal confronted Ben, Ben admitted to having the cigarette, but he did refuse the directions from the vice principal to empty his pockets, because he was looking for more things. So Ben turned to leave. Now the vice principal reached to grab him by the elbow as he was leaving, and so then Ben, kind of threw his arm, and it became a physical altercation. And during this altercation, he was actually, he actually had hit the vice principal a few times and throwing profanities around. And then he had dropped something, and then as he left, the vice principal picked that up, and it was a flask of whiskey. The principal was then contacted, who went searching for Ben, found him, and escorted him to the school resource officer, who charged him with a public offense and 4 violations of the school district's discipline policy. Now, as with anything, they recommended expulsion, and so there was a committee that was put together to review this. And after multiple interviews, they recommended the expulsion because he had 13 weeks left of his senior year, and to place him in an alternative school program to finish the requirements for graduation. So he had a little less than a semester left. Now, the common theme was that Ben would be dangerous to others. So when they interviewed these people, most people had the opinion that Ben was dangerous. And so that's why they ended up expelling him. Now, they did do a manifestation determination since he had ADHD. And this is required by the Individuals with Disabilities Education Act. With Disabilities Education Act, and it was held again only in relation to his ADHD. The reason for this being that it was actually determined by his newer doctor his previous doctor, that he had no issues with the ODD anymore, and so they just focused on the ADHD, and there was no dysrhythmia at all mentioned in anything so far. So that's the focus of that case. Now. The report said that the misconduct, in particular the physical altercation, not necessarily the smoking, but was the physical interaction with the vice principal, was a direct manifestation of his disability. So meaning that they said that was caused by ADHD. Now, in here and in the report, it does state that the parents signed the recommendation there to move Ben to the alternate placement to finish his education and get his degree that way. Now, after the manifestation determination, Again, that they recommend, they said in that manifestation determination and it was a very expedited, quickly done thing, because then this was like the day after the board reviewed it, that manifestation determination, and held up the expulsion. They said that, and they were basing it on 504 of the Vocational Rehabilitation Act and the Americans with Disabilities Act. The Individuals with Disabilities Education Act was not taken into account when they made this ruling. And so basically when they said, yeah, you're going to go to this alternate setting for the last 13 weeks to finish it, the parents then filed for a due process hearing. So the parents were the appellants for this process. Now, so how this came is that Ben and his parents, the appellants, basically said that the school district didn't have the standing to say whether or not Ben should have been eligible for IEP services, because they basically ignored the manifestation determination, which said that he is not which said that he should have been eligible for IEP, and then this caused that, per se, is what they were saying in the manifestation determination. And so then there was the assumption that it would go along with a protection under IDEA. And the Des Moines Independent School District, or the appellees, said that basically, in a sense, it applied to the right to sue and assert claims, and it doesn't do that for the ability to resist those claims. So it's not like the way they're saying that that doesn't apply, basically. But really, the issue of this whole thing, like if you wanted to simplify it into normal speak, as most people would get it that way, is Ben protected by IDEA, even though he was not in an IEP or identified for an IEP at the time. So really the question comes down to, should he have been allotted that? There's some other things, burden of proof and things, but those don't become as big of a deal. This is really the question. Is he protected by IDEA, even though he was not in an IEP at a time, but because he has a disability, does that qualify him for those protections? And so that's really what the most of it comes down to. I'll still address the other ones anyway. Now, just kind of to go back here for a second, there we go. One thing that also I wanted to do is basically, again, just to summarize this, the parents are saying that the school district ignored the manifestation determination and then unilaterally changed where Ben should be. And the school district is saying that there's no standing to bring the suit because they would not have the right to sue or assert injury. The parents wouldn't, because it doesn't apply to a defendant's right to resist claims after they're already in the court. So that was what those kind of clarified into. I had to write that down. Now, again, applicable law. Now, there's a ton of applicable law and precedents. I really, the main focus of the case is the IDEA. We're not looking at the Rehabilitation Act or the Americans with Disabilities Act, which this IDEA really focuses on pretty much everything we're doing. But there's one thing that was an issue in the case, and it was who's supposed to be providing the burden of proof here. So realistically, the parents said, okay, the school district needs to tell us, needs to prove that they have the authority to determine the validity of the manifestation determination. And the school district said the parents have to show that Ben was eligible for an IDEA in order for them to have to follow through with that. There was actually a case going to the Supreme Court at this time, Weiss versus Schaefer, where that was supposed to be resolved. But in essence, they didn't actually come with like a set, here's how it always happens. It just says that the burden of proof lies on the party seeking relief. So in this case, that means that the parents need to show proof. Now that he qualified. Let me double check that for a second. Yes, that's right. So, some precedents. These are only three. I picked three that related to particularly exclusion from IDEA. And so the Hacienda La Puente Unified School District of Los Angeles versus Honig, which the JW versus Fresno Unified School District, and JB versus Independent School District. And these are all examples of students who were not identified at the time as IEP students. So they didn't have an IEP plan or special, they weren't students identified that in need of special services, but they were not excluded from protection under IDEA. So note that, these students were still protected by IDEA, even though they weren't on an IEP or anything. What happens is there's 4 conditions that these precedents set, and in essence, that comes down to like, even is there knowledge, like some kind of knowledge prior to that these kids could have been eligible, or students involved in this could have been eligible for protection under IDEA. And that's something a school district has to take into account prior to doing any kind of disciplinary action like what happened here. And so just that's something to keep in mind for the future reference when we get to the conclusions here. Now, here are some applicable laws. Most of them were just sections of 41530 for Iowa Code. There were some federal ones that went along with it too for all the different, because there were 5 different conclusions, but the main point is that these 41530 really covers the majority of the main focus here as to whether or not the student's covered and things along those lines. One thing I like to keep in mind here is that, the principal acted as the LEA during this whole manifestation determination, and he actually disagreed with that result. And so it's a question that was brought to my mind. What do you do if your LEA is disagreeing with the team's result here? And so I didn't even know if that affects at all, like the Iowa Code, because it says, the team determines this. So like, does it have to be unified, etc.? Also, I was wondering, because another one deals with like the use of illegal substances and such. Well, he had tobacco and whiskey, which is not illegal, but it makes me wonder, was that related or anything like that? The last one was referenced in the case, but it actually relates to hearing aids. So I'm not sure. I think it was just a typo, and I didn't know which one was supposed to be referenced, but I threw it in there because I didn't want to not have it. So the conclusions, some things going on here. The argument that the district's lack standing is without merit. The burden of proof is not a matter of appeal. So the judge's opinion, it's obiter dicta, which means that, it's not setting a precedent, but in this case, it lies on the Ben's parents. The main issue was conclusions 3 onwards. Basically, the LEA, which in this case was the principal or the administration, did not have knowledge that Ben could have been eligible prior to the incident. Therefore, he is not protected under IDEA. Ben's ADHD did not necessitate a need for special education because it didn't affect his educational performance. Some of those cases I referenced earlier, even, and I actually don't know if this was one of them in particular, but there were cases of ADHD, and they had to show that it was educationally affecting him, and obviously for him, Ben, that was not an educational effect. It was all related to behavior. And conclusion 5, there was not a valid evaluation for Ben's need for IDEA services. It was really a rush job, basically. And so the amount of procedural stuff that had to happen wasn't there. So the manifestation determination wasn't valid in that sense. So that doesn't invoke IDEA protections. Now, I agree with the findings of the court completely. First off, if you looked at some of the reference cases, Ben was not struggling academically. So his ADHD does not affect his learning. And he wasn't already identified as an IEP student, whether it could have been for behavior in the past or not. But his ADHD was just not, it wasn't adversely affecting him. So there was no need to take that into account. Also, his behavior, like as I said in the previous cases, while it might have been caused by his ADHD, that's not relevant to whether or not his ADHD qualifies him under IDEA based on those precedent cases. Also, there was a manifestation determination performed, so they were following procedure, although that wasn't very thorough. And so even though that did deem him eligible for IEP services, which seems counterintuitive, it wasn't really valid because it wasn't fully unified, and like I said, it was really rushed, and the sound evidence was not provided for his need of services. Only mostly opinions and behavior worries. You note that basically it was like, oh, these people said this, and I find that one of the least reliable sources of information, because some teachers might refer to a student with a disability as lazy because they don't understand, and other times they think they need behavior IEPs just because they can't manage the classroom. So some implications: you always have to have due process followed. Student information needs to be determined. If there's a need for evaluation or manifestation determination, always check and see if anything that you have would have provided knowledge of the student's need for services, and double check precedents related to the disability of a student involved in any disciplinary action. So always look and see what they've done in the past. Here are some questions. What types of evidence do you believe to be the most valid in determining a child's need for services, and what makes those pieces so trustworthy? And how do you or your school deal with an IEP meeting, where a manifestation determination meeting, where those opinions or action steps or findings are not unified? Thank you.